Right now, a huge legal battle is unfolding in India's Supreme Court, and it's about something that affects millions of us, the safety of the nation's blood supply. At its heart is a really tough question. What is the price of safe blood, and who exactly is supposed to pay for it? Let's get into it.
To really understand what's at stake here, we have to start with the people, with the human cost of all this. The legal petition that kicked this whole thing off uses a really powerful phrase: preventable tragedies. Think about that. This isn't about unavoidable accidents or risks. This is about things going wrong that just shouldn't be.
And at the absolute center of this are children with thalassemia. It's a blood disorder they're born with, and it means they need frequent blood transfusions just to stay alive. But here's the heartbreaking part. The very treatment that's supposed to be saving their lives is in some cases exposing them to HIV.
And listen, this isn't some theoretical what-if scenario. It's happening right now. Just recently, kids in Madhya Pradesh and Jharkhand tested HIV positive after getting transfusions. Now consider this. India is known as the thalassemia capital of the world. So you can see how this isn't just a local issue, it's a full-blown national crisis.
So how on earth is this happening? How is contaminated blood slipping through the cracks? Well, the answer is all in the science of blood testing.
Okay, so here's the technical breakdown, but it's actually pretty simple. Most blood banks in India use a test called ELISA. It looks for antibodies your body makes to fight a virus. But here's the problem. It can take weeks for those antibodies to show up. The alternative that's being proposed is called a Nucleic Acid Test, or NAT, and it is a total game changer. It doesn't bother looking for the antibodies. It looks directly for the virus's own genetic material, which appears way, way earlier.
That dangerous gap in time has a name: the window period. It's that scary time when a blood donor is infected, but the standard test comes back clean. It's a huge blind spot. What NAT does is dramatically shrink that window, taking it from weeks down to just a matter of days. A shorter window means fewer infections get through. It's as simple as that.
And this is what we're talking about, the kind of molecular work that goes into NAT testing. It's an incredibly sensitive technique that can catch viruses like HIV and hepatitis super early, basically slamming that dangerous window shut.
Now, the science seems pretty clear-cut, right? But this fight isn't just happening in a lab. It's happening in a courtroom, and it's all about the law.
See, the petitioner isn't just saying, hey, NAT is a better technology, you should use it. No, they're making a much bigger, much more profound argument. They're claiming that access to safe blood isn't a luxury. It's a fundamental right for every single Indian citizen, guaranteed by the Constitution itself.
This whole case hangs on Article 21, the right to life. And here's the kicker. The Supreme Court has already interpreted this right pretty broadly in the past, saying it includes the right to health and medical care. So the petitioners are basically asking the court to connect the dots. I mean, if you have a right to be healthy, doesn't that obviously include the right to not get a deadly disease from a blood transfusion?
The argument for safety seems like a slam dunk. But now, it smacks right into a very cold, hard reality: money.
And this really is the billion-rupee question the Supreme Court has to figure out. Even if they agree that safe blood is a right, who pays for it? Can the country actually afford to roll out the best, most expensive technology everywhere for everyone? And you don't have to guess what the judges are thinking. This is a direct quote from the hearing. They're basically asking, for states that are already having a tough time just paying salaries, are we about to drop another massive financial burden on their shoulders? It shows you just how real this dilemma is for them.
So faced with this massive conflict, a constitutional right on one side and a tough economic reality on the other, the court has decided not to rush in. Instead, it's taking a very careful, data-first approach before making any final decision.
So for now, the court has hit pause. It's demanding hard data. They've asked the petitioner to go back and get the facts. Which states are already using NAT? In how many hospitals? And the really big question, what does the data say about its cost-effectiveness? The court is making it clear it won't rule on ideals alone. It needs to see the facts on the ground.
And that leaves us right back at the core question of this entire story. The court's final decision, whenever it comes, won't just be about a medical test. It's going to be a powerful statement on one of the toughest questions a country has to face. How do you balance the very real price of safety with the priceless right to life?